This is one of the most significant cases that the justices have decided in recent years. Here, the Supreme Court ruling that President Trump's use of these emergency tariffs that he has implemented are illegal. It's the most significant economic case to reach the high court in years, sweeping implications for the economy and, of course, for presidential power. And at stake here are billions of dollars in revenue that have already been collected by the government. Pamela Wolf, the other significance here is that this is the first time that the 6-3 conservative court has ruled against President Trump in one of these major cases that have gone before the court since he returned to power in January. Now, we are still going through this case, but this is something we have been waiting for. The court said that it would take up this case on an expedited basis. So they're deciding, even though it's a significant case now, because, of course, this has enormous implications.
Guys, welcome back. Adam is here, guys. Two branches of government are pushing back against Trump simultaneously, the judiciary dropping a constitutional wrecking ball on his second-term strategy, and Congress sharpening the tools the founders built specifically to remove a president who's lost the republic's confidence. These aren't separate stories arriving at inconvenient times. This is what happens when a presidency pushes so hard against constitutional guardrails that multiple branches snap back in unison.
And Vedika Bahal is with me in the studio. So, Vedika, Donald Trump may have announced a ceasefire in Iran, but it's done little to quieten the growing wave of Democratic lawmakers calling for his removal via the 25th Amendment. Tell us more.
Yes, Jenny, it's true that scores of Democrats have been raising the alarm about Donald Trump's mental stability and have been calling for his removal, saying that he is unfit to serve. And this is after he used genocidal language at Iran on Tuesday, where he posted, "A whole civilization will die tonight, never to be brought back again." There was also his expletive-laden Easter Sunday post, where he told Iran to open the strait or that they will be living in hell. And this tentative ceasefire agreement hasn't done much to quash these calls for removal, because over 80 House Democrats have made social media posts saying that Trump's cabinet should invoke the 25th Amendment to the Constitution, declaring him unfit to serve, or Congress should impeach and convict him, or both.
When the courts say you cannot govern the way you promised, and Congress formally debates whether you should govern at all, you're not managing a crisis anymore. You're in freefall. Let's start with the judicial hammer, because it landed with the kind of precision that leaves a permanent scar on the historical record. The Supreme Court of the United States, in a 6-3 ruling that defied the lazy partisan expectations of every pundit in town, declared that the president's sweeping emergency tariff authority was a constitutional fantasy. The opinion, penned by the Chief Justice himself, was not ambiguous.
But first, breaking tonight, the U.S. Supreme Court hands President Trump a major defeat. Justices ruling 6-3. The president does not have the authority to impose tariffs under emergency powers. President Trump says the justices who voted against him are, quote, a disgrace to our nation, fools and lapdogs for rhinos. And he is working on ways around the ruling. He says he'll have a solution. We have Fox team coverage. Peter Doocy has additional reaction to the decision from the White House. We begin tonight with Fox News chief legal correspondent, anchor of Fox News Sunday, Shannon Bream. Good evening, Shannon.
Good evening, Brett. Well, the president says he is deeply disappointed in the court, but he's not deterred. And while he's moving forward with Plan B, he's not missing the opportunity to take some shots at the justices who did not rule in his favor today.
It's stated in language that will be quoted in law schools for a century that the president cannot treat emergency and trade statutes as if they were a blank check drawn on the account of the American people. The court stripped away one of the signature governing tools this administration had been counting on to steamroll through the remainder of the term. And here is the twist of the knife that makes this wound fatal to the ego of the man in charge. Two of the justices who signed on to this constitutional curb stomping were Neil Gorsuch and Coney Barrett. The very people he personally selected, fought for, and celebrated as his insurance policy against exactly this kind of legal reckoning. They didn't just vote against his policy preference, they voted against his theory of unlimited power.
And I'm ashamed of certain members of the court, absolutely ashamed, for not having the courage to do what's right for our country.
Those harsh words aimed at two of the president's own Supreme Court nominees, along with the other four justices who joined them in finding the president does not have the power to levy tariffs under the International Economic Emergency Powers Act, or IEPA. Chief Justice John Roberts writing for the majority. The president asserts the extraordinary power to unilaterally impose tariffs of unlimited amount, duration, and scope. He must identify clear congressional authorization to exercise it. Finding none, the majority concluded, we hold that IEPA does not authorize the president to impose tariffs.
That is a signal from the highest bench in the land that the constitutional box around this presidency is not just theoretical. It is made of titanium, and it is being locked by the very hands he trusted to keep it open. Now, pivot your gaze from the quiet, dusty solemnity of the Supreme Court chamber to the chaotic, gilded circus of Capitol Hill. Because while the justices were reading the Constitution, Congress was reading the room. More than 70 Democrats, and the number is not static, it is a living, breathing, growing organism of dissent, have publicly called for his removal. The trigger? A social media post that threatened the annihilation of an entire civilization with a specific countdown clock attached to it. That post has now morphed from a late-night rant into a formal piece of evidence. New articles of impeachment have been filed, dense with legal jargon but clear in their intent, accusing the president of usurping congressional war powers and committing acts that flirt dangerously with the definition of war crimes. And it's not just impeachment. Senators and representatives are invoking the specter of the 25th Amendment, using the specific chilling language of inability to discharge the duties of the office. There are demands for emergency sessions. There are calls for immediate action, a departure from the slow, deliberate pace of institutional deliberation that usually protects incumbents from the consequences of their own chaos. Two directions, two separate institutions, one devastating, synchronized conclusion. This presidency has exceeded the constitutional license to operate. And the combination of these two forces, the courts narrowing what he can do and Congress threatening to end the doing entirely, is what makes this moment the most precarious of his entire political life. This is the convergence, the squeeze. A presidency that looks like a fortress from the outside is discovering that the foundation is cracking from the weight of its own hubris. Let's be surgically precise about what is actually happening here. Because the distinction between a shortened calendar and a castrated agenda is the difference between understanding this story and being duped by the spin. No piece of paper from any court can magically erase the remaining days of this term. The election was held, the votes were counted, and the calendar flips toward the next inauguration regardless of the noise. That is arithmetic, and arithmetic is undefeated. But what the courts are cutting, and what the cuts term framing accurately captures, is the effective power of the presidency. It's the toolkit, it's the leverage, it's the specific, actionable mechanisms that were supposed to make the next few years a masterclass in unilateral dominance. The plan was simple. Use emergency declarations and broad statutory interpretations to govern around Congress, to pressure foreign governments into submission, and to reshape the global economic order with the stroke of a pen and the tap of a post button. The Supreme Court just looked at that plan and said, "No, you will not." The major questions doctrine, a legal principle that requires Congress to speak clearly if it wants to grant vast power to the executive, has been deployed like a bunker buster against the administration's entire operating theory. And while the judiciary is saying, "You lack the authority," the legislative branch is saying, "And we lack the confidence." The impeachment push and the 25th Amendment chatter are the political counterparts to the legal ruling. They are the argument that the Iran War Authority has been stretched beyond recognition and that the unhinged nature of the threats being made publicly constitutes a fitness crisis. The term isn't being shortened by a day, but the power to use that time effectively, that is being amputated piece by piece by both the court and the Congress in a synchronized pincer movement that this administration simply did not see coming. Here is the timeline that matters, because the sequence of these body blows is what creates the compounding effect that is now suffocating the West Wing. First, the post. That specific, time-stamped threat of civilizational destruction with an ultimatum attached. It hung in the digital air like a poison cloud. Next, the ruling, 6-3. The Supreme Court tells the president that his favorite economic weapon is unconstitutional. Then, the walkout. Senators, having been summoned for a classified briefing on the Iran situation, simply stood up and left. They were fed a diet of non-answers about cost, legal authority, and endgame strategy, and they decided their time was better spent elsewhere. That is a visceral, public display of contempt from the very body that holds the power of the purse and the sword. Following that, the dam broke on the House side. More than 70 members went on the record demanding removal. Specific constitutional mechanisms were named. Specific quotes were logged. Then came the formal filing. 13 counts of impeachment with nearly 100 co-signers. A federal judge, in a separate but equally damning emergency order, observed that the pattern of governance on display carries a logic structurally similar to martial rule. Retired military brass, people who have actually worn the uniform and commanded troops in harm's way, began publicly questioning the strategic rationale of the Iran campaign. And as if that wasn't enough, the national counterterrorism chief walked out the door, resigning with a parting shot that Iran posed no imminent threat and that this entire military adventure was driven by external political pressure rather than genuine national security. All of this didn't happen over a year. It happened in a compressed window so tight you could barely catch your breath between headlines. Each event feeds the next. The court ruling makes the impeachment talk seem less like partisan theater and more like a necessary constitutional intervention. The military resignations give weight to the legal arguments. This is compounding pressure, the kind that crushes even the sturdiest political machines. And this is the specific constitutional trap that has been laid. The argument being made by the proponents of removal is no longer just a vague grievance. It is a legal brief in real time. The Constitution, in Article 1, Section 8, gives Congress, not the President, the power to declare war. The War Powers Act is explicit. You have 48 hours to notify Congress when you commit forces to hostilities, and you have a hard stop of 60 days plus a 30-day withdrawal period unless they authorize you to stay. This Iran campaign has blown past those statutory limits, and the president has publicly claimed the right to continue it indefinitely based solely on his own judgment. That combination, an unauthorized launch, an unauthorized continuation, and an explicit rejection of congressional authority to constrain it, is the heart of Representative Larson's 13-count impeachment resolution. It charges a criminal war of aggression. And then there is the civilization-level threat. International law experts, those who spend their lives parsing the Geneva Conventions, have started to characterize that language as potentially constituting a prohibited threat against a civilian population. That's not a political talking point. That's a potential war crime. When senators like Murphy and Markey and representatives like Coney invoke the 25th Amendment, they are applying the inability to discharge standard to a president whose public conduct demonstrates judgment failures in the precise areas, nuclear authority, military command, foreign policy, that require the steadiest of hands. These are not vague political accusations. These are specific constitutional arguments grounded in specific documented conduct, and they are now the mainstream position of a significant and vocal bloc of the United States Congress, permanently etched into the official record, ready to be weaponized in every campaign ad and every future investigation. Let's dig into the engine room of this crisis and examine the specific dimensions of this two-front squeeze. First, there is the effective power-cutting dimension. This is the tangible result of the Supreme Court ruling. The tariff tool wasn't just a policy preference. It was the Swiss Army knife of this administration's foreign policy. It was the coercive diplomatic weapon, the economic equivalent of a carrier strike group, deployable anywhere, anytime, without the annoying interference of a congressional vote. With that tool now ruled unconstitutional under the major questions doctrine, the administration's ability to threaten and deliver economic pain has been publicly and permanently diminished. Every foreign government watching from Beijing to Brussels has recalculated the leverage equation. The court has essentially said, if you want to do something this big, you need to go ask Congress for a permission slip. And as we know, this administration's relationship with the legislative process is, shall we say, strained. The tools are gone, and they don't come back when the news cycle shifts. They require legislation, and that is a game this White House has proven consistently incapable of winning. There is the removal probability reality check. Let's be brutally honest so we maintain our credibility. The votes for actual removal are not there today. Republicans control the House. The Senate requires a 2/3 supermajority for conviction. The political math as of this moment does not add up to a perp walk out of the West Wing, but stating that reality does not diminish the significance of the removal push. It amplifies it. Because this push is not about today's vote count. It is about building a permanent constitutional record. It is about forcing every single Republican member in a competitive district to make a documented public choice. Do I defend the civilization post and the unauthorized war, or do I admit there is a constitutional problem? There is no comfortable option. This process is the accountability. It sustains the conversation at maximum volume while every other institutional pressure, from the courts, from the military, from the markets, bears down. And it lays the groundwork for a future where, if the 2026 midterms shift the math dramatically, the infrastructure for removal is already built and tested. The institutional independence signal. This is the psychological kill shot. Trump's entire political brand has been built on the myth of institutional capture. The Supreme Court is my people. Congress is my people. The claim is that he has realigned the machinery of government to protect him. The simultaneous pushback from his own justices and his own party members shatters that illusion in the most public way imaginable. Gorsuch and Barrett applied conservative legal principles, the very principles he promised to champion, to constrain his power. Members of his own party walked out of a briefing rather than tolerate more obfuscation. Voices within his coalition used the word unhinged to describe his rhetoric. The institutions he claimed to own are demonstrating in real time and on the permanent record that they have their own institutional survival instincts and constitutional obligations that override personal loyalty. That is a signal to the markets, to foreign governments, and to voters that the strongman image is a facade, and behind the facade is a very vulnerable politician. The tool replacement problem. An administration that loses a major governing tool has three options, all of them bad. Option 1, find a different statute to do the same thing. This runs immediately into the same major questions doctrine brick wall. The problem isn't the specific law he used, it's the underlying theory of unilateral power. Any alternative will face the same constitutional challenge. Option 2, work with Congress to get explicit authorization. This requires building legislative coalitions, engaging in the messy process of lawmaking, and making compromises. This administration was explicitly designed to avoid that process. Option 3, abandon the policy objective. This means admitting that the courts have permanently neutered a key promise of the presidency. There are no good choices. The accumulation of these tool removals, with congressional authorization as the only key to the locked toolbox, is what makes the effective shortening of this term so brutally real. Finally, the two-front pressure amplification. These two crises, the court ruling and the impeachment push, do not just coexist. They feed each other like a feedback loop of political doom. The court ruling weakens the president's governing capacity and signals to the world that he is not as powerful as he claims. That demonstrated weakness makes the congressional removal demands seem less like a fringe fantasy and more like a rational response to a presidency in decline. Conversely, the congressional removal demands intensify the political damage of the court ruling. They transform a legal setback into another confirmed data point in a documented pattern of constitutional overreach that Congress is formally saying warrants the most serious response available. The courts say the tools are illegal. Congress says the wielder of those tools should be removed. When both institutions speak in the same constitutional language at the same time, the pressure is not doubled, it is squared. Let's synthesize this into a clear four-point framework that gives you the complete operational picture of where this presidency stands and where it is heading. Point 1. The court rulings cut the power, not the calendar. The blank check theory of emergency economic authority is dead, killed by a 6-3 majority that included the president's own appointees applying the conservative legal principles he championed. The major questions doctrine is now a permanent roadblock across immigration, domestic security, and foreign policy. These powers cannot be restored by a new executive order or a fiery rally speech. They require an act of Congress. And the inability to secure that act of Congress is the central strategic failure of this administration. The term is being cut in the only dimension that ultimately matters, the practical ability to effect change. The impeachment alert is real because the record is permanent. Forget the immediate vote count. Focus on the architecture being built. Over 70 named members of Congress demanding removal, 13 articles of impeachment with nearly 100 co-signers, specific 25th Amendment arguments from named senators. This record is now the property of the American people and the world. It cannot be walked back. It is the infrastructure that will shape every future accountability effort, every 2026 campaign ad, and every historical assessment of this era. The process is the punishment, and it is reshaping the political landscape in real time. The convergence creates a new kind of political gravity. The two-direction squeeze, judicial rebuke and legislative revolt, creates a combined political impact that is exponentially greater than the sum of its parts. Foreign governments see both signals and adjust their risk assessments accordingly. Republican members calculating their survival odds see both the legal precedent and the political firestorm and realize there is no safe harbor. The convergence is not a coincidence. It is one constitutional story being told from two different institutional mouths, and the verdict is unanimous. This presidency is in a state of advanced institutional decay. The 2026 trajectory is being written right now. The accumulated weight of judicial defeats, congressional removal demands, military criticism, and national security resignations is the anvil upon which the midterm elections will be forged. Every Republican member in a competitive district is now making the cold calculation. Is association with this administration an asset or a liability? The impeachment alert is the loudest current expression of that accumulated weight. The court ruling is the most authoritative. Together, they are creating an electoral environment where the president's own party may begin to view him not as a leader, but as a weight dragging them toward the bottom of the sea. A presidency that looks powerful on paper but is running out of both tools, and time is a presidency whose political allies have the most difficult math to solve. And the answer that more and more of them are arriving at in private is the answer that makes this impeachment alert the most consequential warning siren of this entire administration. This is the reckoning. I'll see you in the next one.